thank you all for joining us today, and I'd like to welcome Brent if he wants to unmute himself. Welcome Brent along to talk with us today. So thanks, mate, for joining us.
Thanks, Ashley. Thanks for having me here.
So we're going to be jumping in and talking about grouping provisions today, because I think it's something that's really starting to pick up in intensity that we've seen through a number of clients. But before I jump into that topic, just a couple of little updates for those who aren't as tight in the insolvency world as we are. There's certainly been a real increase in activity that we're seeing from the ATO. Their level of aggressiveness, I think, particularly in the last 6 weeks, has gone through the roof. We're seeing the continued rise in use of director penalty notices, but even more so now, the creditor stat demands seem to be flowing through at a great rate of knots. And that's certainly a big thing to keep an eye on for your clients. Again, I talk about it all the time, just making sure that the ASIC records are right so that you're actually getting the notices, and getting them through to clients quickly is really important. One of the other things that I will say that I've found to be really, really valuable for clients at the moment is that the MyGov system is really working to the advantage of clients. I had a client just a couple of weeks ago who thought that he was going to be close to being attacked by the ATO. We got him to start checking his MyGov every week, and he actually got there was notification in his MyGov account, not that he was going to get a director penalty notice. It came up on his client account within his MyGov, showing that he had a director penalty notice coming. As it turned out, that notice in his statement actually came up 7 days before the director penalty notice actually appeared. So we actually ended up getting 28 days to deal with it rather than the 21 of the statement. And if you wait for the mail version coming through the snail mail, it's another week for that to come through the mail. So we go from having 14 days to deal with a client to nearly 28 days to deal with a director penalty notice. So certainly something, if you've got your own newsletters, to be making a note of getting anyone who has any type of tax debt to be regularly checking their MyGov accounts, because they'll actually get a heads up well before anyone else. If anyone wants any more specific details on what to look for or how to do it, if you're going to put it in your newsletter, please feel free to reach out and touch base with me, and I can talk you through what to look for. So, but without, that's probably enough of that sort of stuff. You came along to look at grouping. So Brent, as I said, welcome along. Brent Lodding's from Robert James Lawyers, and certainly been both a very good friend and colleague of mine for well over 10 years now. Really, really, really smart lawyer. Really love working with him. And but I'll let you give a bit of background on who you are and where you fit into the world. Brent?
Thanks, Ashley. Try and fit in the world as best possible. As you mentioned, partner at Robert James Lawyers in Melbourne. I've been practicing lawyer for a bit over 25 years, which gives away my age somewhat, and mainly practice in insolvency and restructuring areas, litigation, building and construction work. So I do a lot of work with Jonge and their clients, helping them out at various stages of the process. And Robert James Lawyers, quite apart from that, we also have a strong commercial practice, tax practice, and the like. So we cover all necessary areas for trusts and businesses.
Awesome. We'll get stuck into this grouping. And I think, I guess from my point of view, this became a really hot topic for us over probably the last 8 or 9 weeks, because we've had a number of matters that have popped up that have actually almost sort of gone, hey, we really need to relook at what grouping is all about. But let's just talk about it in the total corporate landscape to start with, and then we can jump into some detail after that.
Yeah, look, it's become a really hot topic, as you say. So essentially, as a starting point, in order to differentiate grouping from it, we know that the corporate entity is a legal entity who owes a debt, unless there's a specific guarantor who puts their hand up to be liable for it in the event of default. The legal entity that has the debt is the one responsible for it. So you can't make someone else responsible for that debt. The corporate veil, as it's called, is protected by legislation, particularly the Corporations Act, and a lot of the asset protection work we do is designed to keep debts and assets well and truly protected. So there are limited circumstances and specific parts of legislation that are allowed to look through the corporate veil. That particularly relates, and for our purposes today, to associated entities and related bodies corporate. Liquidators have certain powers for pursuing insolvent trading and the like. But regardless of that, as we all know, structures can still be put in place to try and protect assets and companies to make sure that they're not caught for other people's debts. Essentially, and unfortunately, grouping provisions have been drafted as a means of getting around this, a type of anti-avoidance measure, if you will, and to get payment of one entity's debt from another entity or entities in a corporate group.
Right. So, and I think that you talk about the corporate veil. It's certainly one thing that I've talked about on the webinar before, is that legislation and and private creditors are looking for ways to break that all the time. Like the director penalty notice is a big example of how they're trying to move beyond the corporate veil. But when we're talking about grouping, what sort of areas of legislation do we have that are having this ability to jump through the corporate veil?
Yeah, you're right. And government bodies in particular have become increasingly savvy at how they do it. And they use, as most of you are probably aware, a lot of data matching technology, ATO, SRO, Workcover and so forth, all compare notes now, and it's done instantaneously through technology. And that's being increasingly used to group companies and make someone responsible for other people's debt. So there's a whole bunch of different government entities that can do it, and legislation that helps them. We've got, for example, the Gambling Tax Act, Windfall Gains Tax Act, the Land Tax Act. I'll call it the Workcover Act. It's got a much longer name. And also for insurance superannuation purposes, we've got the Co-Invest Act as well as the ones that are probably more familiar to people but are slightly different, such as the tax Income Tax Assessment Act and GST provisions.
Yep. Okay. So certainly and it seems to be growing, all this legislation that's allowing grouping. And I know that the impact of grouping when we're looking at restructures for Jonge is something that we really need to consider in the pre-planning. We've talked before about that, what pre-work needs to be done, and grouping is a big part of that now. Because if you could liquidate one company just because that's where the debt is, it doesn't mean that it's over if you're not considering all the grouping provisions. But the one that really is, I guess, probably the hot button, and the one I think I'd say this across probably all states, but I know in Victoria we've got a government that gave away a whole bucket load of money in GST, and they seem to be very excited about trying to get it back here in Victoria. So let's start with the big one, which is payroll tax. Why don't you talk about how those grouping provisions work?
Yeah, and the Payroll Tax Act is probably the best one to look at. It's applied probably the most aggressively by the SRO, and it has provisions that are mirrored to a greater or lesser extent in a lot of the other acts that we're talking about. So they're essentially, for our purposes, about 15 sections in between of the payroll acts that are relevant. They capture and are able to group entities. The commissioner gets the discretion to do it, so it's no choice of the taxpayer. And they're 5 main requirements, and that's captured in the legislation as well as in private rulings by the SRO. So you need to be a related body corporate within the meanings of the Corps Act. There needs to be common employees between the entities, and there needs to be a controlling interest. This is something I'll be touching on a little later in this talk, but a controlling interest is an important and necessary element, either between the businesses or between the corporations or the entities that control the corporations. And then we just need the company to be a member of 2 or more groups, and that allows the grouping to go on, as far as the SRO can reach, essentially. So if a company falls within, 1 or more of these provisions, and there's no checklist as such, it's one of those balancing acts which people hate to hear because we can't give a definitive answer. But if you fall within those things, then you can be caught in grouping, and then if you are caught in your group, then there's significant effects and results for you, because in a payroll tax sense, where you think you might be free of payroll tax, you can all of a sudden be subject to it because of the pooling of the entire group's employee responsibilities and so forth. So it's really important for companies and their tax position, and as Ashley touched on, really important also for asset protection, because there are certain particular ways that's mainly done in Australia, and we all do it, and we'll see shortly that that may actually do more harm than good if you're not set up properly.
Yeah, and I think that's a good point. This isn't just about someone who can't pay their debt and we've got grouping provisions. We've got to be looking at it from an asset protection point of view and that longer point of view. And if your group isn't set up right, then it can end really, really badly. Yeah.
Look, the SRO uses these provisions regularly to recoup unpaid payroll tax. It's had particular application that we've seen, obviously, in circumstances where a company goes into liquidation, and then there's some form of connection. You may not be able to see it, certainly as a layperson, and even when it's pointed out to you, you may not be able to see it because of the effects of the legislation. But if there is that connection between a director or a company or employees or something else, then you get grouped, and then you're all liable for someone else's tax, and it can be done through just the various tax returns you put in through these entities and the data matching technology.
Yeah, it's certainly very, very scary, and as everyone knows, we at Jonge are very focused on restructuring and being prepared and structured against these regulations is something we need to be really hyper aware of. But can I just ask, as it comes up a few times, is if a group of companies is deemed to be a group by the state revenue, can you be ungrouped? If they deem you to be a group of entities, is it easy to get ungrouped?
Easy is a relative term. As we all know, it's certainly possible to get ungrouped. If you're caught by the relevant provisions that we touched on, or other ones in there, then you're automatically grouped, and then the only way to be ungrouped is by the commissioner exercising his discretion. Now, as no one wants to be relying on the SRO commissioner to exercise the discretion to not pay money to the SRO. It's not obviously a favourable position, but there are things that need to be considered by them, and basically the commissioner is required to have pay account to the degree of mutual ownership, and whether it's not just a common connection, but it occurs occasionally, or it's more tenuous in relation to family interests and the like. And if you meet that checklist, then you will be ungrouped, and if not, then you have the right of appeal through the courts and so forth. So it is possible to get out of it, even once you're found to be done. But obviously, if you can get well structured in the first place, and your team are really good at it, then you can avoid being deemed to be grouped initially. In the first place, yeah. Okay.
So, and I think that's the key statement, or the key thing here is about trying to avoid it in the first place. Like, actually, don't put yourself in a position where you can be grouped. And that whole prevention is better than a cure thing comes into play. And I know one of the issues that we've had recently has been around trusts. So I think it's probably worth really driving down into the trust issue, because I think it's a pretty big one, unfortunately.
Yeah, trusts are the most common vehicle I think we all use, and our clients use, and accountants use to set up businesses, to protect them, to protect assets and protect the directors and so forth. So it's a really important one, and it's certainly not well publicised. But there's certainly been a lot of case law on it, and there is a lot of legislation on it to catch the unwary. So discretionary trusts and discretionary family trusts which we're all very familiar with and use a lot as an effective tax structure, just are not a complete protection against grouping provisions. They certainly can't be just used, in an off-the-rack type fashion, and hope that the standard provisions of a discretionary trust will get you out of a grouping or protect the assets in the way that you think. So, as I said earlier, the Payroll Tax Act and many of the other acts contain provisions which specifically are designed to look through trusts, or even worse than look through them, to deem them to be caught. Yeah.
So, and I know that we've got a real example that I think is probably the easiest way for us to explain just how dangerous it is. Why don't I let you start by telling the story of how, and we'll jump into the detail of it there.
Yeah. So this is a recent one. We've been dealing with it this year, and it's a very common situation. So we had a client had a significant business set up in a perfectly normal way through a discretionary family trust and a corporate vehicle. There was the named beneficiary, and then the standard, other family members and discretionary beneficiaries in there. It was as I said at the outset, it was a traditional off-the-rack discretionary trust. So nothing wrong with it at all, and one that most of us and most of our clients would have in place at the time.
Yeah.
The client then had to restructure the business, unfortunately, caught by COVID, like a lot of people were. And so restructured, a liquidator appointed to that business, another business started, he had asset protection mechanisms in place, another discretionary trust used by a family member for the new business. And the SRO determined that the two companies were related and grouped, and therefore the new clean company was liable for all of the payroll tax debts of the old company, because of the trust provisions, essentially.
And this is where I guess the really scary part of this is, and that's the deeming rule stuff. So it took me a while to get my head around it. So let's sort of jump into how this all plays out, because it's a bit scary, to be honest.
Yeah, it's a bit scary and a bit counterintuitive as well. So again, it's designed in order to avoid, as an anti-avoidance mechanism, and in order to capture and look through things like discretionary trust. So what happens is that the provisions in the Payroll Tax Act mean that if there is a beneficiary who may benefit from a family trust, so even though they're a discretionary beneficiary, they're not a named beneficiary, and it's completely up to the discretion, which hasn't yet been exercised by a trustee, as to whether they will or will not get a benefit, the legislation deems them to be a beneficiary of the trust, which is a pretty scary and horrific thought, but it gets a lot worse, I'm sad to say, because not only are they deemed to be a beneficiary of the trust, but they're also deemed to have a controlling interest in the trust. So all of these discretionary beneficiaries, if we extend our view, all of them are deemed to have at least a 51% controlling interest in that trust, and therefore they're caught by the controlling interest requirements of the Act, and they automatically qualify for grouping. You can't get around the deeming. You don't ever need to have had an exercise of discretion exercised in your favour or received a benefit under the trust. You just need to be a possible discretionary beneficiary. So in this one, if I can get a bit more specific about it, the initial company obviously had the family member as a potential discretionary beneficiary, because whilst they weren't named, they weren't excluded. And Newco did the same thing, again, because it was a family member. Therefore, both family members were deemed to have a controlling interest in both old and Newco, and therefore they're automatically grouped and liable for the entire tax debt.
So, and I think this is the really scary part about this, is that most off-the-rack family trusts will have, say me as the primary beneficiary, and maybe my wife. I might have my kids as secondary beneficiaries, and any other relative is in there. And I know years ago I used to talk about family trusts as basically anyone in the world can be a beneficiary apart from the settler. So you really open, and I'm not saying the payroll tax are going to go and pick up someone who's got a business that they don't even, there's no relationship to, but those, your named beneficiaries and potentially that secondary family connections, all of a sudden they're 50% controlling interest in everything. Or 51%, I guess, and all of a sudden they can join in tax debts that were never actually meant to be joined in the first place. I know when we became clear on this with this matter, I'm certainly having a review of my family trust to make sure that the asset protection will still hold up. But if we're to use another example, which really just shows how scary this is. You brought up another one about a son and a daughter and a father. So let's just talk through that one, because I think that makes it really clear just how scary this can be.
Yeah, if you were looking at your own provisions before, you certainly would be after this one. This wasn't one that we were particularly involved in, but it's a genuine example where just a typical family, parents are retired, self-funded retirees through their family trust. Normal asset protection involved and so forth. Had 2 children, call them son and daughter, each of them reasonably successful in their own rights and ran completely separate businesses. Daughter runs a pet grooming business, son runs a car repair shop. Genuinely separate, had nothing to do with each other, each run through, once again, discretionary family trusts in a what we would consider a normal sort of corporate setup, sensibly set up by their accountant and done properly. Each of those businesses were exempt from payroll tax. The daughter's entity paid around $500,000 of employee wages, and the son around $600,000, and they were both sort of looking to restructure and increase the size of their businesses. They were both successful businesses. Unfortunately, because of the deeming provisions, what happened was they're each deemed to be have controlling interest in not only their own companies through the discretionary trust, but the others also. So daughter had a controlling interest in her company and a controlling interest in son's company. Son, likewise, in both of the businesses. All of a sudden, these 2 exempt businesses now have a significant payroll tax debt because they're not separate and distinct anymore. They need to be pooled. So they're liable for payroll tax. Both of those businesses are jointly and severally liable. So it was it's a horror sort of situation for genuinely separate and distinct businesses. Worse than that, because they're both potential beneficiaries under the parents, superannuation and assets and so forth are now potentially liable to be grouped and be liable for the payroll tax as well. So you get a situation where there's just, genuinely independent companies and businesses there that can be caught by the grouping provisions, and they're just caught. And then they have to rely on once again, the discretion of the commissioner to unwind the grouping.
Yeah, and I think, I'm sure everyone who's listening here has got at least one family group that's quite entrepreneurial. I certainly know, a number of dads who have got kids that have seen their dad in business all their life, and then they've gone off and started businesses. All of a sudden, they could end up having co-joined businesses that they didn't think they'd want to. So it's a pretty horrific one. I haven't seen it used a lot, but it seems to be starting to be used more. As a tale of caution to everyone listening, I would certainly be thinking about having a look at some of your family groups, and particularly, those who might have rural businesses and farming businesses where everyone has their own little trusts and different things and that. It might be worth just having a review. We'll talk about some ways that you can protect against it in a minute. So, but it's certainly a pretty scary one, and one that I wish didn't exist.
Sure.
So the next thing, we might just move a little bit on from payroll tax, because it is, well, although it's very much probably the big one, and it seems to be the legislation that everyone follows with all the other groupings, it's probably worth looking at some of the others. And the other ones that have hit our radar recently has been WorkSafe and Co-Invest. Now we'll come back to co-invest, but even WorkSafe, I was a bit surprised to find out that they had some grouping provisions as well.
Yeah, they do. And again, in their own legislation there, in the relevant act, they've got the ability to demand payment of workers' compensation, insurance premiums, and penalties, importantly, from other entities, say for the one that actually owes those premiums or penalties in the first place, on the basis of them being grouped. So the provisions are pretty similar to those in the Payroll Tax Act, and that's why that was a good one to start with and look at. And that includes deeming provisions in relation to discretionary trusts again. So once again, we're in a situation where if we've got those off-the-rack trusts, they can just be deemed to be a group and therefore liable for the debts of another entity. Again, similarly, the Act itself provides for a discretion for the authority to exclude a company from grouping, and similar factors are in play as to why they would exclude it and exercise that discretion. But once again, if we're relying on the discretion, then that means A, we're already caught, and B, we're spending money on lawyers and so forth, and to try and get out of a debt and a grouping situation, which is best avoided if we can do it from the outset.
Yeah. Okay. So well, it's certainly something. And WorkSafe, I know. I think just in the last month, I've had probably 4 or 5 calls from people who have now got claims against WorkSafe for fairly innocuous things that they seem to be getting more aggressive on. But that's just one for everyone to keep in mind. Now, the one that I didn't know, I had no clue about, and one that you wouldn't have thought would be is co-invest. Now, for those in Victoria, they'll know co-invest as part of the Long Service Leave Portable Long Service Leave Act. So it allows construction workers and others that move between companies and jobs that they can actually still have a long service leave provision put in place and developed. In other states, Q leave, I believe, is what it's called in Queensland. In New South Wales, they don't have a really fancy name for it, but it does exist. And in WA and all, it's actually a requirement in the mining industry. So each state's got their version of it. For today, we'll have a look at co-investments. It's one that obviously we've looked at recently. What talk us through that one, Brent?
Yeah, and look, it's serendipitous that you mentioned all the ones in the other states as well, because the courts across all of the states apply the rulings and decisions from all of the other courts when making their determinations here. So whilst there's not much case law at the moment in relation to co-invest and these provisions, they will draw from other jurisdictions. So, and whilst, as we said, payroll tax and Workcover and so forth are the more aggressive litigants, I think, and enforcing it, there's a very good chance this one will come to the forefront as well. So the grouping provisions in the Co-Invest Act are somewhat more limited than the payroll tax ones that we went through in greater detail earlier. Yeah. But the theories behind them are the same. So essentially, we have a situation where if you're not structured properly and you just have your standard organisational structures and your standard discretionary trust there, then you may well end up liable to pay unpaid long service leave charges of another entity. And once again, you're caught by those provisions, and whilst you've got a right to apply to the Commissioner to ungroup, we're again relying on discretion and again relying on a reversal of the onus there, whereby you have to prove to them why you shouldn't be grouped any longer. So, again, from the outset is the best time to organise with all this and get good advice on it and make sure that you're not caught by the grouping provisions and stuck with someone else's debt. Yeah.
Okay. All right. Well, look, that's I think that the ones that we've talked about now are where it's an automatic deeming or you're deemed to be a group. We can't really have a webinar that's marketed to accountants and bookkeepers without talking about the ATO legislation pieces that sit with grouping. But you mentioned earlier that they're quite different in that it's an elective rather than something that's an automatic and more of an avoidance laws. This is something that you actually do for your own benefit. I don't want to get into those because I actually think between you and I, there's probably more experts in tax grouping listening than there are you and I talking about it. Not that I'm taking away from your knowledge on ATO grouping, but
please take away.
But at a high level, just expand a little bit on the fact that they're optional rather than something that like the SRO.
Yeah, that's right. Look, the one other one we didn't touch on was the Land Tax Act, which also has a lot of similar grouping provisions also. But the ATO ones and GST, they're very different. I mean, they could be the subject of their own separate seminar, as you just touched on. But they're opt-in. Once you opt in, obviously, then you're stuck, and it's an irrevocable opt-in, and that can prove a challenge for us, as Ashley will attest to and well knows down the track when we are restructuring. But they're designed very differently as well. They're designed actually to benefit the trustee, the taxpayer, I should say, to help the taxpayer, and you've got the pooling provisions and other things whereby you can pool losses and so forth. That's not the intention of these grouping provisions with regards to payroll tax, Workcover, etc. They're not designed to help at all. They're just designed for the authority to look through the corporate veil and make other entities liable and collect their money.
Yeah. Okay. So we'll leave, as a general rule, they're generally a good thing and used for the bigger businesses. But I do know I've had a client that was grouped, and that created that then got into financial trouble. So we had to deal with a whole group, just not an individual company. So from my limited knowledge of it, be really careful of using the opt-in groupings because it does mean that everyone's in there for the long haul. You mentioned land tax. I didn't really have that one high on my radar, but is there anything that you want to tell the group about that one that's anything different to what we've spoken about?
No, it's nothing different. I just thought it was worth mentioning because obviously we have properties and so forth, another big area where our clients can all get caught. It's still SRO, it's still subject to the same sorts of provisions. But I'd hate to leave the seminar here without having mentioned it and have people not have that at the forefront of their mind if they're speaking to their clients as well, in terms of setting up structures for properties as well as for businesses.
Yeah, so I think, I mean, that's right. I mean, the land and the value of it, and the land tax, you hear a lot of people complaining about land tax rates and what have you. You wouldn't want those to be crossed across a number of different things. So we've talked about all the horror stories and all the things that can go wrong and everything that we need to avoid. What are some of the things that the guys here listening can think about doing to try and avoid some of these things and not get caught by the provisions?
Yeah, look, it's the same sorts of things that all of your accountant clients and so forth no doubt do every day, in terms of just turning their mind to it. The grouping provisions we've found, particularly recently, now that they're coming to the fore a lot more, are not something that most people have turned their mind to previously. They think a discretionary trust is an all-purpose protection a lot of the time. So it is just looking at each of the clients and each of the businesses or each of their property holdings or whatever separately and independently, and making sure that they're set up to avoid various taxes properly. So not just an off-the-rack trust or something. You need to look at the provisions in there, potentially exclude certain classes or certain specific beneficiaries with a view to a possible later restructure or a different entity structure or something else. That's not particularly difficult to do, but it needs to make sure that the trust deed is properly amended, because the courts will say, well, these things can hinge on one particular word which isn't properly defined or something else. It means often having a look at other family entities, structures, parents, brothers, siblings, etc., as to whether you may be caught by them and whether you need to do a separate deed revoking your entitlement to their family trusts or something similar. Otherwise, you need to amend all sorts of other family trust deeds. So, it's having a look at not just what's in front of you there, but being able to be aware that your clients may get caught and may need to look beyond what's just what they are thinking of at the time. And if you're looking at restructuring down the track, then doing so, it also means, I think, on an ongoing basis, being able to do health checks every now and again, because as businesses grow or kids come into the world or go out on their own for their own businesses or parents retire, then those situations change, and all of a sudden there's a trust you didn't know about, and your entity's caught and liable for another debt. So it's not anything particularly visionary or spectacular, but it's an area where often professional advice is required, or you just need to know where to look and how to look for it.
And well, to say it's not very visionary, I think that's probably undercutting things a little bit, because I do think, you know, I think a lot of us would look at a family trust and think, oh, you know, you don't need to worry about the beneficiaries because it's discretion. That, you know, you don't, you know, if they're sitting in there, if we don't give them any money, they're not getting anything from it. And you talk about that example of the son and the daughter, you know, they're off running their own businesses. They may have had separate accountants that were just looking at them individually. But, you know, having the knowledge, I guess, now that everyone will have is that the deeming of 51% control just because you're a beneficiary, I certainly never thought that my daughter would have a benefit. She's a beneficiary, but I didn't think she'd have a controlling interest from certain legislation. So, you know, it is something that is worth being really careful of, and it's good to know that you can actually alter the deeds to remove people if you now know that is an issue for one of the clients. And when we know that when we're looking at restructures, putting in a second family trust in a restructure, we'll need to make sure that we have the exclusions in place. So I think it's certainly a really interesting, I want to call it a development because it's sort of something new to us, but it's obviously been in the legislation for a while that we just need to be aware of.
Yeah, and even if I can just touch on it again, even though those clients, you know, no doubt will all go away today and think, oh crap, you know, Joe Bloggs, my client here, we only set up last week and there are issues, or he's been a client for 10 years and there are issues now that we weren't aware of. Those things can be dealt with. It may need to do some certain minuting of meetings. It may need a change to the trust deed, or it may just need a separate deed to revoke certain interests or vary them somehow. But, you know, it's not too late to fix those things. Again, it just needs the awareness to have a look at it and then to get some advice on it and fix it.
Yeah, I think that's it. These all of our webinars are really about awareness and trying to help you know, our referrer base to know that there are things that can be done out there. So that sort of pretty much wraps up what we were going to talk about. There was one last thing that I wanted to I was going to say in the research that I did for this webinar, but it was actually more your team that did the research. There was a really interesting case, and something you had has actually just prompted another comment I wanted to make about it. It's the case is Cessnock Tyres versus the State Revenue in New South Wales. You talk about fair and succession planning and all the rest of it. This was a group where Dad owned the company. The three boys worked for Dad. Dad retired, and the boys were given a shop each, effectively. Yep. And you would think that would be normal succession planning, but the SRO got a little bit excited with these boys and tried to group them again, even though they'd all gone off separately and run their own parts of the business. So again, different issue, and I won't go into that because I didn't pre-prepare you that I was going to ask about it. But one of the really interesting things in that case that I saw, which again is something I harp on in these webinars all the time, is about intercompany loans. So the three boys had separated into their own companies, but there was still lending happening between the boys. And that was actually capturing one of where the state revenue used that as part of the capturing that they were an interrelated company group. And one of the big points I think they raised about that was the fact that these loans were intercompany loans, weren't commercial. Can I just get you to touch a little bit on that part, with your legal brain rather than my different brain, how that, what the explanations and all of that was?
Yeah, look, you're right, and it's really heavy going, that decision as well. It's a big one. It's wading through. It's a great cure for insomnia if anyone's having trouble sleeping at night. But the part about the intercompany loans is very interesting, as you say, because essentially that's the way in which they were caught in this one. The applicants argued that the loans weren't really significant. They didn't relate to the business operations of the various shops and entities there. For example, one of the loans was about $90,000, and it was used for the purpose of purchasing some land on which they were going to operate some of the business and so forth. And that $90,000 loan, in the context of millions of dollars in turnover, was pretty much insignificant. That didn't really hold water for them. The SRO argued that the loan arrangements, as Ashley touched on, lacked the proper commercial characteristics. That they weren't documented and so forth. They were unsecured, they were interest free and the like. So not normal commercial loans, which lent to the suggestion that those companies were connected. And they said further that the purchase of land isn't a reason for them to get out of it, because the land was used for business purposes and the like. So and that succeeded. So business loans, whilst they're documented as such in the books, just doing it that way and not going through the proper channels, which I know is a pet topic of Ashley's, and documenting it properly, securing it properly and so forth, is just setting yourself up for these sorts of issues.
Yeah. And I think, it's just another reason why I can say, please secure intercompany loans and director loans. So at least they're commercial and not just caught as part of a family group scenario. So look, we'll wrap up there, Brent. I really appreciate all the work you've done to put into talking about today and all the rest of it. So I'll open up the floor to any questions. If people have got some, they can put it in the chat box to do that, or use the electronic, put up your hand, and we'll find you and do it. And Jazz has jumped in with the poll early on us today. But anything to wrap up that you just want to sort of wrap up the whole piece with today, Brent?
Look, not that we haven't touched on, just the summary of what we've said today is that all of these institutions are designed to look around and straight through the structures that I think all of us are very comfortable and familiar with, such as family trusts. And there just needs to be some caution exercised and some attention paid to it. So just, as we always say, avoiding the one size fits all or the off the rack version of things and thinking that you'll be covered for all potential events. That rarely works, and it certainly doesn't work when the legislators have gone out of their way to make sure that they go through those sorts of structures. So yeah, it's just a bit of mindfulness always will help the clients at the end of the day.
Thank you. Yeah, so guys, that's pretty much it. I can't see anyone who's put up the electronic hand, and no one's put anything in the chat box yet. But what I will say from my point of view is, please, if you've got a specific question, don't be afraid to look Brent up and have a chat with him about your scenario. I've always found Brent to be a really commercial lawyer, and we'll look at things in the right light. But I think just becoming aware of this is, again, just a really good thing to keep in mind. I've talked in the past about that we're seeing a huge shift to a lot of people coming out of business. There is a lot of succession planning being talked about now, and sometimes the succession planning won't think about all of these because, again, one of my favourite phrases from Stephen Covey is one of his rules is always start with the end in mind. The problem is not everyone thinks about the end. That's not the fun part. They always assume that the end is going to be when it's great and they're making billions of dollars. But unfortunately, not everyone does. So you need to think about the other side of it as well. So that wraps up today. Again, Brent, thank you very much. Really appreciate the efforts that you put into this. For everyone else, thank you for joining us again today. Look forward to, we'll have another session again. Well, there's another one this afternoon, but next month we'll have a new topic and a new speaker coming in to talk about something interesting. If you do come across anything interesting that you'd like us to talk about, again, please email me, give me a call. I'm happy to try and get speakers in to talk about anything that you think is relevant to you, as well as what I think is. So that's it for us today. Thank you, Brent.
Thanks,
Thank
Ashley.
you everyone for listening, and we'll see you all again soon.